Point of order. The first agenda item is adoption of the proposed agenda. So I hear a motion we adopt the proposed agenda.
I'd like to make the motion.
Let's get it on the floor, but it's adopted not first. Do I hear a motion that we adopt it?
I'll move to adopt it.
Is there a second? Any discussion?
Yes, sir.
Recognize the president.
The proposed agenda indicates that someone will be giving some report on very sensitive matters in open session. According to the proposed agenda, we would then go into executive session because these sensitive matters concern personnel and legal matters as allowed by Section 30-4-7 of the State's Freedom of Information Act. I don't believe we should receive a report on sensitive personnel and legal matters in open session. First, it would not be wise to raise these issues in open session before we know the facts, before we receive the legal advice and assess the legal and financial risks of the Commission, its individual members, and the retirement system. Secondly, I've been advised that this Commission and its individual members may have significant legal exposure by raising these issues in open session. And thirdly, Section 30-4-7, A1 and A2 of the State's Freedom of Information Act allows the Commission to discuss personnel matters and receive legal advice, respectively, in executive session. This is allowed so the Commission members may have an open and honest and freely assess the legal and financial risks to the Commission and its members. In this case, the Commission should take advantage of the state's FOI laws and to receive the report on personnel matters in executive session. Only then can we be assured that we know the facts and that they have been assessed and their risks have been assessed, and prudently receive a report in open session on a matter that has risk and legal exposure. Finally, all sides of this issue cannot speak openly and honestly in open session because of the threat of litigation and the action proposed to be taken. Presenting one side of the story in open session when others will not be able to fully voice their side is not appropriate. For these and other reasons, I move that the agenda be amended to delete the open report, delete the report from the open session. And according to state law, move that first item, the report, into the executive session.
Is there a second?
I'll second it.
All in favor, signify by saying aye.
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 All opposed by like sign? Say nay. Your vote. Yeah. Nays have it. Now we proceed to the vote on the agenda. Is there any further discussion on the agenda? All in favor of it?
Mayor Reynolds, can you repeat that into your outcome?
The nays had it. The motion was defeated. 2 votes in favor and the remaining votes against.
All right, hey, ma'am, I'd like to make a motion
All right.
that we then reorder the agenda to take the executive session first.
I'll second that.
I thought that's the motion we just voted down.
No, that motion was to strike the item and to carry it into executive session. I'm making the motion to reorder them.
Okay. And you second that, Mr. Wells?
Yes, sir.
Right. All in favor signify by saying aye.
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 All opposed say nay. Nays have it. Now do I hear a vote on the motion to adopt the proposed agenda?
I move adoption of the agenda.
We'll proceed to vote. All in favor of adopting the agenda, it's already been seconded. All in favor signify by saying aye.
Aye.
All opposed by like sign? Ayes have it.
And I'll abstain. You can report me as an abstention.
I've called this special meeting, as all of you know, to address bullying and improper communication by our staff. Most, if not all, commissioners have directly observed the bullying and such episodes. The particular triggering event for this meeting was the September 30th telephone call to our Chief Operating Officer. Curtis Loftus berated his subordinate.
Mr. Chairman,
with
for personal reference, I'm going to take my leave. inappropriate. There's an old saying that goes something like, you have beaten your wife to death. And there's no way to answer that question properly. There's no due process. There's been no investigation.
Mr. Loftus, you
I'm
may
sorry,
take-
I'm sorry. And I'm-
Order, please.
Yeah,
You may
I'm going to
come
leave.
to order. You may leave.
Yes,
but you
I
may
will
not-
leave.
You may not address the commission while someone else has the floor. You can do one or the other.
All right.
You can stay and be quiet
No, sir.
for
I
now.
will leave.
or
Thank
may
you very
leave.
much, sir. Thank you.
The particular triggering event for this meeting was the September 30th telephone call to our chief operating officer. Curtis Loftus berated his subordinate with profanity and abusive name calling. For clarity, alas, I must specify, quote, "I'm not putting up with more of your bullshit," close quote, and quote, "you're a son of a bitch," close quote. The earliest instance occurred within the first few weeks of our COO's hiring, when Mr. Loftus castigated Mr. Oliver in the presence of others, questioning whether he was the right man for this job at your exorbitant salary. And I close that quote. I expect to receive more information and elaboration during executive session, following which there may be motions to be made. Documentation on the characteristic hectoring, the prolonged harassment will be attached to and made a part of the record of this meeting and of the commission. An anti-bullying policy draft has been posted on the secure portal for all commissioners to review. I know each of you has a copy in your folder, the green folder, so that we may open the floor for any discussion of that policy. Do I hear a motion?
I move that we adopt the anti-bullying policy.
Is there a second?
I'll second it.
The motion is on the floor. Is there any discussion?
I just want to be clear.
Is Robert there?
Yes, sir.
Yes.
Yeah. This with the chairman just this morning. Again, I'm at a little bit of a disadvantage being on the road, not having a lot of time to prepare. Is there currently an employee policy manual that applies to commission employees?
That applies to the employees, yet the answer is yes. There are personnel policies that apply to the commission employees, and those policies do cover somewhat similar ground.
Do we have copies of that language?
No, but Mr. Gillespie, if I could just elaborate on what I just said, the anti-bullying policy that's before you right now actually would augment and complement the existing personnel policies, in that this anti-bullying policy would clearly cover, would be intended to and would cover the commissioners as well as employees. The personnel policies in place do not, arguably at least, do not apply to the commissioners. So this augments that which already
So
exists.
the commissioners are not employees, therefore
Yeah,
it doesn't apply to us.
exactly.
And the only way we would have enforcement power is if the commissioners were subject to some sort of anti-bullying.
So can I ask a follow-up question on that, Robert? Right.
Sure.
Is this in lieu of what is currently there? So does this replace that language? You said augment. Does it?
Augment.
Just an augmentation. What language is?
You probably didn't hear Robert, but he
Yeah.
said augment.
Augment.
Right.
And by that you mean it does not replace it,
No.
it supplements it, adds to it
Supplement.
in addition to.
Exactly.
Okay, could I ask, just for clarification, it covers employees and every commissioner exactly the same, it applies equally across the board, is that correct?
Oh, I'm sorry, wait. What, the existing personnel policies covering the employees,
Right, there would be an
Yeah.
anti-harassment policy that would cover employees, and there's also workplace violence,
Mhm.
anti-workplace violence policy that would cover employees. But the proposed
Dory,
policy.
Dory, can you get closer to the phone? I can't hear you.
there's a
Come on.
speaker here, too.
In fact, come on even closer.
Alan, can you hear me?
I can hear you better now.
Okay. The personnel policies consist of, or the related policies that are in the personnel book that do not apply per se to the commissioners would be an anti-harassment policy, which covers some of these items, as well as there's a workplace violence section that would cover some of the items as well. But the difference with this policy is it would clearly cover commissioners where the personnel policies are, you know, by nature to cover the staff of the commission.
Okay, but this applies to, this particular anti-bullying policy applies to employees and commissioners equally, is that correct?
That's correct.
Okay.
Oh, sorry.
And, no, that's not, and I'm assuming our general counsel, that this is a policy that is standard across the industry or comparable to other standard anti-bullying policies across the industry, and, something.
A draft I saw earlier that Robert was working on
Okay.
was the AB, the American Bar Association model anti-bullying.
Okay,
policy.
that's what I want to know.
And I have a question, Robert, Dory. And I know it's a non-exhaustive list of what might be an example of bullying, but the first one, A, work-related harassment. And I understand work-related harassment in general terms. And then we have in the parenthetical, work overload, unrealistic deadlines, meaningless tasks. Who decides what's work overload, or what's meaningless, or what is an unrealistic deadline?
Mr. Chairman,
You know, it's not, you may have some employees
Down
that
at the
feel like
bottom,
they're being.
it says in the sole and final discretion of the commission in a proceeding which the offending commissioner may not vote.
Okay.
And I guess I have one question about that, right? I mean, you know, given that these are labor laws, right, is that the proper venue? I mean, what is the, you know, proper procedure, right, on how to handle a workforce labor-related issue?
Do you want me to
Well,
start? Yeah.
generally, I mean, most state agencies would be subject to the Grievance Act rights under, you know, the grievance laws. We are statutorily exempt from those. So plugging in an administrative level type policy, which would report to the commission, doesn't preclude additional remedies, you know, that somebody has under the law. This is just a layer to try to resolve an issue before it would reach that heightened level.
In technical
Right,
legal
but-
terms, that would make this what's called the final agency action, right?
Essentially, right?
Determination,
Yeah.
Correct. And in terms of grievance act, I mean, where's that stuff go?
It goes through the state OHR and then a grievance panel.
But again.
We're
just
not
to-
subject to that.
But the employees here are not subject to the Grievance
Right,
Act.
that's the important point here.
And there are other
Right,
federal.
but can I ask a question, while they're exempt, couldn't we still adopt that?
Theoretically, I suppose you could opt in.
I don't think you could force your way into you couldn't force your way into their process. You could certainly adopt it as a guide to follow, but you couldn't adopt it so that you force your way into their that's the covered employees due process. You couldn't force your way into that process. You could certainly use them as a guideline.
It looks to me like the legislature clearly and intentionally wanted to leave that discretion to us, to the commission.
All employee, I'm sorry, this is Nancy Seeley. All employees of the commission by statute are employees at will and are specifically exempt from the State Grievance Act. The commission could adopt a similar policy, but I think Mr. Avant's correct in that since we are exempt from the State Grievance Act, we could not have, say, the grievance panel here are employee grievances.
Right, but presumably, I mean, and this is just my reaction, right, I mean, at least serves as an established working model, right? I mean, I'm not inclined to, just because we're exempt, totally, you know, establish new ground if there's a working model that we should follow.
Well, and this, to me, this seems to follow that model in a lot of respects.
There are other procedural.
Well, instead of your panel, you've got the commission.
Right.
Right, but presumably under the agreements, right, there's some sort of hearing, right? There's discovery, there's a hearing,
Right.
there's some procedural elements, right, that this is basically silent on, correct?
Which would leave the commission free under whatever circumstances might arise to adopt whatever procedural niceties we think are appropriate at the time. Or, no, it could cover all cases or just one particular one. In order, the commission would be free to adopt procedural rules. to the extent we don't give notice and opportunity to be heard to an employee, we would need to think about that carefully.
So then is it clear in the absence of this, that our employees of the commission do not have presently the avenue to redress the event of?
No, they do. They do have redress directly to the courts.
Just not through the grievance process.
It's
But
not
not
through
there's
the
no
grievance process.
state grievance process that they can.
Did you repeat that, Robert?
So, Mr. Giove just asked a question then about just trying to clarify grievance rights then, or avenues of redress for commission employees who find themselves, believe that they're, have experienced something like bullying. And right now, given a bit of the gap that sort of exists, absent adoption of a policy like this, our workforce could go directly to court.
And that would be their only recourse.
That-
They would have no
that-
income.
Right, at present.
Right, whereas a state employee normally has to go through the grievance process first, or does not even have the avenue.
First.
Has to.
Has to first.
Right. So it's like a mediation process.
Administrative.
It's an administrative.
In front of an
yeah,
ALJ.
It's litigation,
Yeah,
it's not
it's-
mediation,
yeah.
it's litigation. It's just before a state agency.
Yeah.
Without this policy, our employees have no recourse and
Other than to go to court.
Other than to go to court.
Correct.
Correct.
Okay.
and it seems prudent to.
Now, does this require them to follow this procedure? Like, is a state employee required to go through that grievance process?
Other state employees, not our workforce again, but other state employees, yes, they must use the, if they work for a unit of state government covered by the Grievance Act, they have no choice but to
That's correct.
follow its procedures, yeah. But Alan, am I answering your question?
Yeah, well, I guess my question is, can we require the same of our employees, right? Like, what we don't want to do is provide this avenue and still be subject to, I mean, the whole point of procedures like that is to limit your, your liability and your exposure, right? Which essentially right now, because the only recourse to our employees would be to go to court, right? Which is a much more unknown process, right? Unless we, in conjunction with this policy mandated, right, that that certain procedures are followed.
So again, as Mr. Aban said a few minutes ago, I think this is the answer to your observation, Mr. Gillespie, that, absent some sort of gap-filling policy like the one before you, we could not just simply decree that that we are opting into the State Employee Grievance Act. That is not quite available, we don't believe. But one could, I suppose, the commission could, I suppose, decide to adopt that as a model or use that as the guidance for creation of its own sort of process, somewhat analogous process.
Any further discussion, questions? All in favor, signify by saying aye. All opposed, like sign. Ayes have it. Thank you. Do I hear a motion that we go into executive session to discuss personal matters and proceed legally? I hear a motion. Do I hear a second?
I'll make that motion.
We have Mr. Gillespie will make the motion and Mr. Joby will second. Since you couldn't quite hear what, it had already been made and seconded several times. We'll give you credit. All right, we'll go into executive session now. I will invite the legal staff and the COO and the CIO to remain, and we'll excuse everybody else.
And I requested permission from the commissioners to attend the executive session. I asked because the chief of staff is referenced in what I understand an action you're going to consider, and I would like an opportunity to address the staff before you take the action involving the chief of staff and, quite frankly, the general counsel from the treasurer's office.
And we do not permit staff of anyone other than commissioner, of anyone other than commission staff to participate in the executive session except upon invitation of the commission. Our standing policy has not been to extend that invitation just because the commissioner is not present. And if it seems appropriate to us that you address us, that's something that we could decide during the executive session and come out and invest.
I would ask that you consider that very much, please. I'll be brief, I promise, and I think it's important.
Okay, we've got one item to do first. If we think it's appropriate, and I have no reason to think we wouldn't think it's appropriate, we'll come get it.
Okay, thank you.
We appreciate all the people who participated in the executive session. Next item on the agenda, I have a motion which the commissioners have in front of you. It's in writing. It's motion headed Mr. Oliver separation from employment, and I move that motion be adopted. Is there a second?
Yes.
Mr. Joby seconds it. Mr. Oliver, could you read that motion? I mean, Mr. Feinstein, could you read that motion?
Yes, Mr. Chairman. Whereas, after careful consideration, the commission believes that, for the good of both the commission and Mr. Gary A. Oliver, the notice of resignation tendered by Mr. Oliver on September 30, 2013 should be accepted, subject to the terms of this resolution. Now, therefore, the commission agrees as follows. The commission acknowledges Mr. Oliver's significant positive contributions to the commission and overall excellent performance above expectations since he began employment. Based on the existence of possible legal claims, the commission hereby waives advance notice of Mr. Oliver's resignation and accepts Mr. Oliver's resignation to become effective after consultation with counsel and completion of all required documentation. Although Mr. Oliver has submitted a resignation, there is an involuntary component to the termination of his employment, which is the moral equivalent to a constructive discharge. Based on the above, the chairman or his designee, in consultation with legal counsel for the RSIC, is hereby authorized to negotiate a good faith settlement of possible legal claims between RSIC and Mr. Oliver. The commission authorizes RSIC staff to seek approval of the Attorney General to retain external associate counsel to review and provide advice relating to the settlement of any such possible claims between RSIC and Mr. Oliver. And upon completion of settlement negotiations, the commission authorizes the chairman or his designee to execute any documents, take any other actions necessary to implement this directive, and effectuate any agreement and release resulting therefrom. That's the text of the motion, sir.
Is there any discussion? Call for a vote. All in favor signify by saying aye.
Aye.
Ayes have it. And it's adopted. Ms. Gunn, any other motion?
One other. Yes, there should be one other motion.
Yeah, I move that we adopt the motion for the chief operating officer.
Is there a second?
I second it.
Motion by Ms. Gunnarsson, second by Mr. Pritchett. Mr. Feinstein, would you read that resolution?
Yes, Mr. Chairman. Whereas after considering the exigencies of the situation, the needs of the organization, and the length of time to conduct the COO search, including the benefits of having an agency head in place prior to the start of the next legislative session and the commencement of an extensive enterprise-wide fiduciary audit, the Commission believes it is now in the best interest of the Commission to implement a solution that will quickly provide stable administrative and operational leadership for the RSIC. And whereas the Commission believes that the most optimal solution now is to appoint an acting COO, and whereas the Commission believes that the Honorable W. Greg Ryberg is highly qualified to serve as acting COO, And whereas the commission wishes to offer, and Mr. Ryberg has expressed his desire to accept the position of the commission's chief operating officer, now therefore the commission agrees as follows. Number one, any provisions of the governance policies to the contrary notwithstanding, including but not limited to Governance Policy 1E2 and Governance Policy 3I3, the commission agrees to waive application of its governance policies and to hire the Honorable W. Greg Ryberg as the commission's chief operating officer at a salary of $161,000 per year. The COO is an at-will employee of the commission and will serve until the commission determines that a new COO search is feasible. Number three, in accordance with the terms of the commission's compensation policy, the COO will not be eligible to participate in the performance incentive compensation program. And last, the chairman or his designee is hereby authorized to execute any documents and take any actions necessary to implement this directive. And that is the text of the motion, sir.
Is there any discussion? All in favor signify by saying aye.
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 All opposed by like sign. Ayes have it, unanimously elected. Is there any further business before the commission? If not, I'll entertain a motion to adjourn.
I move that we adjourn.
It's probably the last time I'll hear you say those words. Is there a second? Any opposition or discussion? All in favor, signify by saying aye.
Aye.
We are
Thank you.